Hi everybody, this is Kelsey. Today is December 23rd, and the lighting may not be that good, but we're going to have to hang in there and do the best I can do, okay? I'm going to continue now with People versus Wicks. Again, the reason that I'm doing this is because I recently typed my name in a search engine and just wanted to see what came up, because I have the website, so I have to see what's being said out there, right? And I saw People versus Wicks. People versus Wicks. I didn't like that very much. Okay? I've never murdered anybody, that is to say, with malice and a forethought or premeditation. I've never taken any life. I've never killed anybody, that is to say, shooting at a deer or something and my bullet accidentally taken a life. I've never taken anybody's life, okay, intentionally or otherwise. And so I want to get this straight. My name is out there on the website, on the internet. My website has been out there, okay. So I just want people to know the truth. No, I didn't commit no murder. I did 12 years of my life, more than 12 years of my life in prison. My stepfather died when I was in prison. My favorite uncle died when I was in prison. I had other relatives that died when I was in prison. I didn't get a chance to go to any of their funerals because I was incarcerated. Okay? So, let me just start out. What are we going to start out with? I'm going to start out with an affidavit. An affidavit. This affidavit is dated, the first day of October 1991. I was incarcerated. I was incarcerated about December 20th, December 21st, 1989. So this is about almost 2 years later. To make a long story short, there's 3 points that I put down in this affidavit. I got it sealed by the notary. Point number 2, that I, Kelsey Wicks, at no time wore a bike jacket, as is written at page 280 in the trial transcript. Defendant wore a sports coat and casual dress slacks on either a suit each day of the trial proceedings. Okay? So, I didn't wear a bike jacket. Now, you can envision what a bike jacket looked like yourself. I know I have my own ideas or envisionings of what a bike jacket looks like. But I certainly don't want that information, that untrue information, going up and being available, okay, to trial judge or to the appellate court judges. Here, this is my appeal. When a person gets convicted, they can appeal your case. Appeal your case and say, hey, I think a mistake was made at court. They found me guilty and I'm truly innocent. And so what happens is the appellate court judges have access to the trial transcript. And at page 280, I didn't want them to see that somebody pointed me out at the courtroom and said that I had on a bike jacket. I don't know how that would look to them. Okay? So it's an untruth. And I didn't want them to see any untruth about that. So that's basically what I'm saying. Okay? So that's the end. So that was that point. Let's deal with that. Now, another point that I'm going to make right now is let's continue with this book here. Is that one of the issues that my attorney on appeal, going up to another court, filed, basically contended that the officer had arrested me. Okay. And he said, in the appeal here, he's saying, my attorney wrote, the detectives testified that they considered Wicks a suspect at the time they met Wicks in his apartment building, and one of the detectives who met Wicks in the vestibule of his apartment building admitted that he and his partner had, quote, made the arrest, unquote, sometime that morning. And then my attorney cites page 35. Page 35 of the trial transcript now says, okay, I have it right here. And they're talking to a detective on the witness stand. And it says, now from 10:30 to 4:30, this is not the whole page, almost the whole page, but I'm just going to the meat of what to get to the point. Now from 10:30 to 4:30, Mr. Wicks was in you or your partner's control, basically, correct? Talking to the detective. Question put to the detective on the stand. Well, he was in a room, he replies. I understand that, but I'm saying he was your suspect. You had made the arrest. He was there and you were the ones going in and out questioning him up until about 4:30, correct? And the detective answers, correct. The importance of that is that if I was under arrest, okay, that same morning, and they're saying, and then they indicate, well, there could have been a legal issue that might have raised the point that because he was under arrest and could not leave, held in incommunicado detention, okay, didn't get a chance to talk to anybody, although someone called right on the same page, 35. Were you aware? The question is put to the attorney. I'm sorry, put to the detective. That's on the stand now. Question, were you aware of the fact that an attorney had called the station and specifically was transferred to one of your officers and asked specifically to speak to Kelsey Wicks? The detective answered, no. Next question, were you aware that the attorney was told that everything was under control or words to that effect? No. Very, very serious point there. Because, first of all, the detective admits that I was under arrest, in his opinion, at page 35 here. And then, in addition to that, I did not speak to any friends or relatives or anybody. I was in incommunicado detention by myself and the detectives. That's what that means. Okay? Not being able to, not talking, not saying, I did not talk to anyone. Although an attorney called to speak to me and was told, the question was put to him did he know that an attorney had called for me? And he said no. I should have got a chance to speak to him. Next thing we're going to go right here, real quickly. What's going on here is the prosecutor is saying that one of the witnesses was not going to be called. Let me read on. I understand the defense. She's saying, that's me and my lawyer. I understand the defense may have some witnesses in the court. We would ask that the witnesses be excluded. The judge or the court. All witnesses are excluded from the courtroom if they expect to testify in the case. If there's any ladies or gentlemen, they have to leave the court. Prosecutor. Secondly, if we can please have their name, addresses, date of birth before they testify. Of course, Judge. My attorney answers, I would provide that. I am expecting another one or two witnesses. The court, it will be done over the lunch hour. Apparently, the state has 2 doctors. The prosecutor answers, 1 doctor, Judge. The judge answers, what happened to the second one? The prosecutor says, we will just be calling the 1 doctor. The court, the judge, what happened to the second one? The prosecutor, we will not be calling him as a witness. My attorney, on behalf of the defense, for the last 2 days, They have been telling us they are going to bring in those 2 doctors. The doctor they now say they do not want, we would like to call as our witness, sent the judge. Okay, the doctor we have today is what? A pathologist? The pathologist. The court asked the question. The doctor we have today is what? A pathologist? The prosecutor answers, yes, a pathologist. The court, and after the pathologist testifies, will the state have other additional witnesses? Okay. The doctor, and then the prosecutor answered, no. The court, so the state will rest in, and the prosecutor says yes. The court will break for lunch after this doctor. That is good timing. The prosecutor says fine. The court says okay. My attorney says okay. The courtroom, the judge says the doctor you want is now what? Doctor. What is his name? And my attorney answers, gives the doctors that we want now. Okay? He gives them the name of the doctor that the prosecutor said would not be testifying. You must understand, okay, that the doctor who is now the doctor who apparently is not going to, according to the prosecution, testify or was released, was the treating doctor. He was one of the doctors, the doctor, or one of the early doctors who saw the victim when she was first rolled in after being found in front of the hospital. Okay, that is the doctor we're talking about now. The doctor who had an early view of the victim after she was found. And so the prosecutor says, the judge says, oh, his name. I was told he was going to be here today. Is he in the building? And then the prosecutor says he was here and we released him. After not, we released him. Okay? To make a long story short, I can't really find, I thought I had the rest of it. That would have been 15. My attorney, I can tell you what happened. My attorney didn't like that very much. We wanted an opportunity to examine this doctor, to ask him questions about the injuries to the victim, to see if they somehow matched the statements of the alleged confession. Okay? That is the important part. Okay? We didn't get a chance to talk to him. We talked to the pathologist, the one who said that the jump rope handlers were, quote, not it, as it's stated, as it's written, and Wicks, the people versus Wicks. And then on another question, he asked the same question. He says that the jump ropes were not likely to have caused any injuries to the victim. We talked to them. But we didn't get a chance to talk to the treating doctor, Dr. Smith. My lawyer didn't get a chance to examine him. Okay. The other thing that I want to do is just read to you. People in the public, you don't really have a call to really know anything about confessions. You've never probably been arrested arrested in relation to a charge, and then somehow out of this interlude that you have with the authorities, somehow a confession comes out of this, and then now you've never had to deal with that. But the court has. There's much information written about confessions. Let me give you some information. Let me just read a little information to you here. In the cases of Powell versus Alabama, The United States Supreme Court wrote that every accused person should be given the opportunity to have a lawyer present to prevent them from making disastrous mistakes while in the custody of law enforcement authorities. The fact that a person is educated, how can a person, Kelsey, you've been to college and blah, blah, blah. Let me continue reading what the court said. The fact that a person is educated or has accumulated business experience has no true bearing on the guilt or innocence of the accused in regards to confessions, parentheses, or crimes in general. In Powell versus Alabama, the court wrote, even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with a crime, he is incapable generally of determining for himself whether the indictment is good or bad. He is unfamiliar with the rules of evidence. He requires the guiding hand of counsel at every step in the in the proceedings against him. Without it, though he be not guilty, he faces the danger of conviction because he does not know how to establish his innocence. The United States Supreme Court case also wrote in the case of Crooker versus California, the trial issue of coercion is seldom helpful. Law officers usually testify one way, the accused another. The citizens who have been the victims of these secret inquisitions has little chance to prove coercion. What takes place in the secret confines of the police station may be more critical than what takes place at trial. And the pretrial period is so full of hazards for the accused that if unaided by competent legal advice, he may lose some legitimate defense he may have long before he is arraigned. The innocent as well as the guilty may be caught up in a web of circumstantial evidence, the blanket with my name and former address on it. Circumstantial evidence. I'll read it again. The innocent may, as well as the guilty, may be caught up in a web of circumstantial evidence that is hard to break. He may be guilty of indiscretions, but not of the crime. Okay? So there's all kind of an attorney called the station for me. I had forgot about this gentleman. As I said, I don't read this stuff, but now I remember his name. Okay? Forgot all about that. Okay? What I'm going to do now is go ahead and close. But the only thing I have to say in closing is that there's other information about this case that needs to be known. As I indicated in the video last night, not to tell the full story about this case and other facts and so forth is to leave out Bob Cratchit, Tiny Tim, and Ebenezer Scrooge and the story of the Christmas Carol. The bite marks found on the victim, the information on her, the medical records indicate that she was a small woman. Okay. For a man to do something like that on such a small woman, had a lot of injuries, it indicates, on a lot of abrasions and stuff like that, rather, is what I'm saying. Okay, and I read some of them to you yesterday. Is kind of puzzling. That seems more like something that may have happened. Bite mark? Why would a man have to bite a woman? That seems like it's something more consistent of two women having an altercation. Shalom. I'll talk to you later. Bye-bye.